All right, guys. We had a partial verdict. So big victory, of course, for Raul Valle because he has eliminated the top charges. Now, yes, to answer the question here, um, what's going to happen next for Raul Valle? So here's what's going to go down. And any question of whether they're going to retry this case, I think the prosecutor jumped up before the verdict even came in and said they're going to file what's called an information. What that basically means is the top charges are what he was charged for. Technically, he hasn't been indicted, or he really, at this point, he's been discharged because technically speaking, they were lesser included. So, but double jeopardy does not preclude him from being charged for those lesser included. So, sometime later today, tomorrow, the state will file an information for those charges, charging him with the lessers, which are man one, reckless, assault one, reckless, 2 counts, and assault 2, reckless. He will then be brought in. They'll have a hearing on it. Of course, he'll plead not guilty, or it'll be he'll enter pleas to not guilty, and then they're discussed when the retrial will happen. Of course, everything's totally different now in this trial in the way it'll be handled, because the whole theory of the case now will be based upon the reckless element, and basically saying whether he acted recklessly or not. This actually potentially could be an easier case for the state. I saw some of you say in the comments, yes, if they would have went this route to begin with, yes, 100%, they would have had a much easier trial, because it's a lot different than what they were trying to say. And of course, what they had to try to, they could have also maybe not had to make the deals they made with some of these other players, because they would have been able to just stand on whether or not he was reckless in his actions and behavior, whether he acted recklessly and it resulted in the death of Jimmy McGrath. So, with that said, what's he facing? He's still facing a substantial amount of time in prison. Man one, reckless, still has a 20-year maximum. He still gets up to 20 years on each assault charge. And he gets potentially up to 5 years. Right, I believe I got to double check the assault charge. It might be 10 on the first on the assault one. I believe it's 20 though, but I'll double check that. But I know on the assault 2, it's 5. It's up to 5 years. So I believe it's up to 20 years, and he has a mandatory minimum of 5 on each of the first degree assaults. I believe is what it is. I have to double check that for certain. But he's basically facing, all in all, about 65 years. Now, the difference though between a reckless and an intentional in all of these situations is the way sentencing is treated. And in the state of Connecticut, normally they will sentence at about a third of the max, as what the standard go around is. And that's so if you're looking at that, you're talking about 20 years potentially between the two. And again, that doesn't mean that's if the judge stacks all of them on top. Now remember, this is all part of one event. So the judge would have the ability to potentially go put them all together as concurrent sentences. And Raul Valle, since he was 16 at the time, would be eligible for parole at 60% of his sentence. So reality is he's probably facing about 14 years maximum in prison, all said and done once everything's worked out as a maximum. But that does not mean that's what he would get at sentencing time. So there's a lot of room now for negotiation and to figure out how to resolve this case going forward by the state and maybe avoid a trial. I have a feeling trial will be avoided, but maybe not. There will not be any 40-year offers this time around. I mean, that wouldn't even make sense. They could try to do that, but I don't think that would even be considered given the charges he's facing. But at this point, the prosecution, I hope, takes a moment, steps away, takes a deep breath, and says, okay, what are we doing here? Give me one moment here. I'm looking up. All right, so I'm going to get this answer here in just a moment. Let's see here. It is 20 years. I was right, but it is at least a minimum mandatory of 5 years. It's not suspendable. So he would have to do. So if he would have been convicted, or if he finds himself convicted of a first degree assault, which is a Class B felony in Connecticut, I was right. It's a maximum of 20, at least 5 years imprisonment, non-suspendable under subsection A1. So therefore, you're not going to be able there. He's got to do 5. Now, assault 2, I believe, is 10, but I don't think there's a mandatory minimum. Or maybe there is. Let me see here. Assault 2. All right, let's take a look here. So yeah, it's up to 5 years. So I was right. 1 year though, it's a mandatory minimum of 1 year. So Raul Valle would be, if he was convicted of these offenses, he would have a mandatory minimum of 11 years. But then again, he gets a 60% possibility of a 60. I believe he gets the benefit of a 60% potential, but he may. I don't know if that would. Let me find out here. Hold on. All right, so let me see here. Doing some calculating here. And manslaughter is 1 to 20. There's no minimum on that one. There's no mandatory minimum. However, assault in the first degree. So what he would be looking at, let's see here. Total mandatory minimum in this case would be basically 10 years, or 11 years because of the assault too. However, so he would be, if he gets convicted of all these counts, he would serve 10 years minimum. Okay, that's locked in. 10 years minimum. He would probably realistically be looking at, I would say, again, probably somewhere in a range of up to 20 years, depending on where the judge went. But he would be facing a mandatory minimum of 10, a likely sentence of 20, and it could be potentially the judge could have the flexibility of going up to 30. So he's probably facing a realistic sentence of 20 to 30 years on the front end. And basically, he would be eligible for parole then after serving 60% of his time. So let's just say, that would put him at, as I said, about 14 years is what he'd be looking at. So you'll see him get right out of the courtroom. but he wouldn't be eligible for parole earlier than 14 years if he got a 20-year sentence. Now, if he got the 10-year sentence, he has to serve every bit of that 10-year sentence because he does not, the 10 years is not parolable in Connecticut. That's the way it works. So see what Bad Barney had to say here. So for those of you who are just tuning in, the verdict is as follows. He was found not guilty of first degree or the top charge. The jury acquitted him of man one intentional. They were deadlocked on man one reckless. They acquitted him or found him not guilty of man one intentional. They were deadlocked on, or not man one, sorry, assault one intentional. On assault one reckless, they were deadlocked on both counts. And then on assault two intentional, he was acquitted. But on assault two reckless, they were deadlocked. So he will be, at this particular juncture, he was allowed to walk out of the courtroom. The state will have to decide if they're going to go forward. And since he was acquitted of all the top charges, it will require them to refile charges for the essentially man one reckless, assault one reckless, 2 counts, and then assault two reckless, of which we were just discussing. He's facing a maximum of 65 years. A mandatory minimum of 10 years would have to be served if he was convicted of all 4 of those offenses. And he's likely to get a sentence somewhere ranging between 20 to 30 years, although normally they would sentence at about 1/3 of the potential possible sentence. So probably likely a 20-year sentence, which he would serve 14 of. But he would not be eligible to get out of prison less than 10 if he gets convicted of all of them, because there's a mandatory minimum that he has to serve in the state of Connecticut. And since he is, regardless of his juvenile status, he would be required to serve that mandatory minimum because he's treated as an adult. So that is where we stand on that. A huge victory, nonetheless. Huge victory. But at the same time, too, it means additional legal expenses for his family, and it means probably more likely than not another trial that will happen in the near future. But it will be a totally different trial than what we saw, because the theory of the trial will have to be adjusted and amended because they will be dealing with the reckless component, not an intentional component. So they won't be able to argue that there was intentional. They're going to have to come up with a whole new theory. In fact, that's why I say the prosecutor, the only reason why I'm going over all of this, some would say the prosecutor should just not go forward, but they're going to go forward more likely than not, because we heard the prosecutor jump up before the verdict was even read in open court, and he said, "We intend to file an information." And the judge said, "Slow down, Mr. Prosecutor. Let's receive the verdict. I don't know when your intent is to file that, but normally it's they're supposed to give some consideration to how this trial went and whether or not it makes sense to spend additional state money on these charges, and what's the likelihood that they would be, or that they would get a guilty verdict. And they need to take a long, hard look at the evidence and their witnesses, because this jury obviously struggled with this for nearly 3 days and came back with a split verdict. So, I believe they should have come back with a complete not guilty verdict. But the fact that they came back with this, I think, speaks to the weakness of the state's case. I would love to know what the jury's where the jury was as far as deadlock wise on these reckless charges. My assumption is they were probably split, but we also know, we heard that there was an 11-1 hung, which means there might be one person in there that was holding off a complete and full acquittal. And that person was like, I'm not willing to let him off completely, but who knows? It could have been, they all were in agreement that he was reckless, but he wasn't doing anything intentional. Who knows? These juries are can surprise you when you find out what was actually really going on back there and what their theory of the case is. Hopefully Court TV or somebody will get a juror on that can give us a little insight into what's going on. I also believe that the state, again, I thought it was in bad taste that the prosecutor's standing up there talking about filing informations when he hasn't even had a chance to talk to the jurors. He hasn't had a chance to really sit back and really take a look at the trial as a whole and make decisions, on what they want to do. But I think, if you ask me how this resolves itself, I think now the state will be forced to give or to make an offer of a more reasonable plea deal. And to me, I think they would need to work out something that would allow this to get worked out without another trial, without a need to call all those witnesses again, without a need to put the McGrath family back through this. But I don't know. Maybe Raul Valle will not accept any scenario that would send him to prison, because he's going to go to prison for a period of time if he accepts a plea deal. But we'll see. But I believe that, to me, as for reasons stated, which I stated in depth and detail, they did not meet the burden of proof in this case. They did not eliminate all doubts as to whether or not this was a self-defense case. And the problem they have is they have no witness that is reliable. And you have no one that I think would allow 12 jurors without pause to say, yeah, he acted, whether recklessly or intentionally, that he acted in either of those manners in a criminal way. I just don't believe it, because remember, self-defense negates either. If he was acting in self-defense, so the jury here has left us with a verdict that basically just says that he recklessly went in there and I guess started swinging the knife and then just recklessly kills people. I mean, this is going to be a difficult case for the state to try again, I think. But like I said, the prosecutor has already indicated that they're ready to rock and roll, although I think they're going to have to really sit down and try to evaluate how they can put together a case for retrial with the evidence they have that's going to fit this. Because remember, juries, it doesn't really matter. These are lesser included offenses. So, they're lessers of the bigger, and a lot of times things get included, and it's not really that they haven't had to go make a full case as to how they're planning to prove these offenses beyond a reasonable doubt. They're there as options to settle disputes or to give a jury a landing spot. Well, now they couldn't figure out what landing spot they wanted to go to, and now they're left with the landing spots. And that's not, I don't think, going to make for a very good trial for the state when they got to come in and explain how he recklessly acted. I mean, how does their version of events fit with reckless? And there's going to be motion in limines. There's going to be evidence that the defense is going to be able to come in and say, well, they don't get to burn that in because that's not what the theory of the case is. That's not what the charges are. The jury already said that didn't happen. He was already acquitted of those. So they're not going to be able to go in and bring that in. They can't go in and tarnish the new jury. They have to focus on recklessness. They have to focus on the theory of recklessness. How was he reckless? And again, talking to these jurors will be very helpful in figuring that out, but in figuring out whether the state and how the state wants to proceed with this. So we're going to keep our eye on this and see what happens. But man, what a process, and what a jury verdict, and what a jury deliberation. I knew it was going to be complicated. I knew the jury was going to be confused. Let's check out some of your all's comments here and see what y'all are thinking. So let's go a little bit back here. We're just jump in with Donald 1951 says, I guess they didn't believe the dark-haired girl who said she saw him stab Jimmy, who was not involved in the fight. Well, Donald, I think that they could believe her and come to a reckless verdict. In fact, I posted that testimony up in the portion of that. And one of the things that he does say, which someone yesterday was pointing it out. I can't remember who it was yesterday that was pointing it out, but I promised him I'd put that portion up. Part of recklessness is he has this knife out, and it appears he falls because he's trying to defend himself. And again, this is how a theory of recklessness could develop in the killing of Jimmy McGrath. Is he's he falls, and they could say, okay, he's got the knife out. It was reckless. The knife's in hand. He's entering back in. He's wanting to defend himself, and he goes to turn around to get away from somebody, and boom, knife plunges into Jimmy McGrath. He wasn't intending. It wasn't necessarily that he was reckless. He shouldn't have been out running around and moving around with a knife. And of course, one of the elements of proving reckless manslaughter is that you have to have known that grievous bodily harm could occur, and people do know that. One defense component would say, well, if that's the state's theory of things, they could obviously attack that and say, well, if he was in defending himself, a jury would have to sit and say. But a juror back in that room could view that testimony in a way that they could think justifies this. Heavenly Presley says, not partial. He is free. Oh my God, y'all know how court works. Well, it was a partial. It was a partial, Heavenly, and unfortunately, the prosecutor already spoke to their intentions. We'll see if they change their mind. We hope they don't. De Silva and Rawls' testimony corroborate. Jack was behind them, and when De Silva was in the yard. Yeah, Bert, I went and looked and I saw, I believe, what you were talking about, but I could not see anything that stood out to me that made me think that person was doing anything other than maybe getting involved in the fracas. I'm assuming you were thinking that maybe there was an indication that Jack was doing something. But I played it back. I played it back at 0.25 speed. I was watching it on the big screen and trying to decipher it. But Dina El Shama says, so there'll be another trial for the reckless component. I thought him walking free after the verdict means he's fully squared, even though they came back with a split verdict. No, he's not. They have a right to retry him on those charges. That a mistrial was declared on those. We will just see what happens. But no, it's not that he's not fully acquitted. They can retry him, and they've already said that they intend to do that. So we will see what happens. We will see what happens here. Bad Barney says, Heavenly, all up to the DA considering it costs, new evidence, or witnesses. Generally, all up to the DA. That is correct. But remember, this has complicated the DA's life greatly because they now have to, and again, hold on one second here. I'm going to pull up the elements. What elements must... So here we go. So they're going to have to essentially, okay, so here it is. A person is guilty of manslaughter in the first degree when under circumstances, evincing an extreme indifference to human life, they recklessly engage in conduct which creates a grave risk of death to another person and thereby cause the death of another person. So they've got to prove reckless conduct, and a person acts recklessly. This is under the law here. Acts recklessly with respect to a result when they are aware of and consciously disregard a substantial and unjustifiable risk that such result will occur. So again, the defense would very well be able to position a self-defense argument here, but they have to show that, again, the reckless conduct would be taking a knife into a crowd of people and swinging it around could be considered reckless. Extreme indifference to human life. Well, you're doing that. That's showing an indifference, and that would be more than ordinary. Now, again, you got to remember that that reckless conduct must occur under circumstances showing extreme indifference to human life. There's a couple components to that. One is it's got to be more than ordinary reckless. It has to suggest a callous disregard for how dangerous or lethal the behavior is. And, you might, for instance, what this is really meant for is like driving 120 miles an hour on a highway in a residential neighborhood where there's small children around and the speed limit's 15 miles an hour and you plunge into a kid, or you fire a gun into a crowd of people because you're trying to disperse them. And maybe your intent was to disperse them, but you should know that is that is extremely reckless and shows a disregard for human life, because obviously you shoot a gun into a crowd, somebody could die. Then there also, in addition, there has to be, the conduct has to create a grave, not just theoretical, but a grave risk of death to another. And that requires that the proof the act had a high probability of causing death, not just harm or injury. And this is where a 3-inch pocket knife plays into effect, that the state would argue, or the defense could argue, well, he brings that in there. Why would you think a 3-inch pocket knife would cause? I mean, so the ways the defense can defend against the reckless is kind of open a little bit more, because the defense is going to get to focus on things like that. In the state, they could use, in this case, they could potentially try to bring in someone that would be an expert witness that would say, hey, a pocket, but again, that's going to be difficult. I mean, how would anyone think a pocket knife, a 3-inch pocket knife, would necessarily be something that would be deadly? This was not a stiletto knife or switchblade. So the defense can make that argument and say, if he, it's got to be grave risk of death, and whether or not that rises to that or not. And then they've got to prove that, which in this case they've already done. They've got to prove that the proximate cause of death, that the proximate cause and cause in fact was a result of the actions of that. So obviously he stabs him. That's really not something that's going to be in dispute. But that's what the state's facing. So as you can see, there doesn't have to be intent. They don't have to prove it was in the heat of passion. They don't have to prove, they don't even have to prove a weapon was involved. But in this case, a weapon's going to be involved, because it's going to be the use of the knife is going to be part of the idea that says that was conduct that he should have known could have caused death. But that's going to be an issue that the defense could call, like I said, could call a witness and say, hey, do you think pocket knives are deadly weapons? And if they can show the jury or raise doubt that he would think that, then now the question could be asked of Raul Valle on the witness stand. When you had that pocket knife in your hand, did you think it would kill anybody? No. Okay. So then therefore, if he didn't think that would have caused death, that was simply going to injure people, but not gravely, just get people off of you, that's now a viable defense for Raul Valle. So let's just see here. We've got Dina El Shama says, so he may be looking into jail time based. How long on average would that be? Well, yes, he's looking. He still faces, if they were to refile these charges as the reckless charges, he's facing up to 65 years in prison. He faces up to 20. He's going to face, if he was convicted of all 4, which again, if they find him to be acting recklessly, in this case, it would probably be an easier deliberation, and one that would probably have the domino effect in the verdict, that the top one is guilty and then all of them else are guilty, because you're dealing with recklessness now. In a theory of recklessness, it's got to be extreme, but anyways, so he would be facing a minimum of 10 years, mandatory minimum of 10 years if convicted of all 4. Likely sentence would fall between 20 and 30 years. Connecticut normally sentences at about a third of the maximum when it's a reckless charge, because reckless is looked at differently because of the intent difference, meaning it wasn't an intentional act. So let's say he got 20 years, he's looking at 14, where he would be parole eligible to get out about 14 years. But that's the reality he's looking at if convicted of everything. But we're a long way away from that. I think he's in a great position right now. His defense is in a great position right now. They get to go back. He's already testified once. I mean, that would be problematic if he changes anything in his testimony, but he's going to be a little bit more comfortable on the witness stand this time. And they're going to be able to go into a few different areas now, that the only thing on the table is reckless acts. And it's more, what did you think? What would you think? Did you think this would be a weapon that would cause death? Or were you, just try? All of those are now viable defenses as you're trying to approach the different elements of the crime. The assault charges actually have the mandatory minimums attached to them. So those are the ones that are kind of the ones that he wants to steer clear of. So if he was working at a plea bargain, if I'm his attorney, they would drop the assaults as part of the plea bargain. So there's no mandatory minimum attached. And this is what I would be doing if I was his attorney. and this is the way you sell it to Raul Valle, is you say, okay, the state gets to argue for 20 years. There's no mandatory minimum on the man one. You argue, you get him to agree to a man one, takes a plea. He's facing 1 to 1 year minimum up to 20 years. If he takes the man one, they drop the other assault charges. There's no mandatory minimum now, and the judge has the discretion to sentence him. And, since it's a reckless charge, the defense attorney would explain to him, hey, listen, you're looking at probably 6 to 8 year sentence right now. And then if the judge does give him a 6 to 8 year sentence, since there's no mandatory minimum, he would be eligible for parole possibly in 2 to 3 years. And he gets out and puts this behind him. Now, the problem is he takes a felony on his record, and he may not like that. But to me, I think that is a way you could go, or even go at it and say, get him to agree to man 2, which is 10-year maximum. And then, you're in the neighborhood of where there's a cap on this thing. And the prosecution can then explain to the McGrath family, we're going to get to go into court. You're going to get to come in. You're going to get to talk about the impact this had on you. And you're going to get to ask the judge to give him 20 years. And if the judge gives him 20 years, he's only going to do 60% anyway. So he's really facing, in that type of scenario, 14 years maximum. And that's the selling point that you get to young Raul Valle and say, listen, we've capped your total exposure to 14 years, which is very unlikely in this case because the judge is going to be sentencing you under a theory of recklessness. And maybe we get a year, maybe you just go do a year in the House of Corrections. Now, maybe he doesn't think that that's going to be something he can handle at any shape or form. And maybe he doesn't want to do that at all. Maybe there's never a way you can ever talk him into agreeing to anything that could put him at, there. Heavenly Presley, yes, I'm putting out scenarios. These are scenarios that could possibly go in ways that this thing could be resolved. Okay, Beast, there's no need for that. A moderator, we need to take care of that type of stuff. That's not cool. I don't know if he's showing up now. He might be timed out. I can see it on my end. I got to go in and look at my back end, but I hope he's taken care of because we don't need to be saying things of that nature. But yeah. So am I happy with this verdict? I'm happy he got acquitted. I wish they would have acquitted him of everything because I think that is exactly what should have happened here. But you know what? That's not always how it goes. Not always how it goes. 1 second here. Yeah, let me go in here and just check this out here on the other end. I'm looking at the back end of the chat. We want to make sure that is taken care of. Hopefully it is. I don't see it. I don't think I see the comment anymore. Good. So with that said, guys, so let's take on this one. So you can stab someone and just walk. Nice jury. Should have at least been reckless. Okay, well, first of all, it's not that simple. The jury didn't just, yes, you could stab someone and walk if it's done in self-defense. So maybe, reckless. What's the theory of recklessness that you think holds up? If in the circumstances we learned in the trial we watched, one of the things is like I said, is the jury is establishing when, and this was, I think, one of the big problems the state had, is the state actually put up contradictory evidence as to when he got the knife. They started out saying, and again, this was to maintain their theory of intent and to say that this was an intentional killing that allowed them to argue for the top charge, the big M. And that was that he returned to the vehicle and got the knife and didn't have the knife when he first walked down. Then we have Jack Schneider comes in and says, no, I threw it to him and he got it that way. And that became a big problem for the state because a contradiction like that, where they have two theories and they can't tell you what happened, just simply goes into saying they can't prove what happened. And if they can't prove when the knife came in, if they can't prove when he had the knife, if they can't prove the order of things, if it's not that is in and of itself a reasonable doubt. How can you then prove whether or not this guy did this intentionally or whether it was self-defense? And you go, well, let's look at the witnesses. And yeah, they called 25 witnesses. They called 25 witnesses who contradicted themselves, who got hung up in lies, who told inconsistent statements, whose stories changed over time, whose initial statements did not, were vague or lacked details that all of a sudden 3 years later they're coming to the witness stand and talking about. That's a problem for the state. And if you're going to rely on those witnesses to say, hey, we're going to, without question, convict this man of, or this young kid of an intentional homicide, I don't think, I don't think juries like that too much. So Lori Pergetti says, Taz, I agree 100% as well. Erica, it was the right decision. Erica says it was self-defense, right verdict. Joni Davis says, the question to me in the end, could he and his friends have fled before using the knife? And I think Joni Davis, I'm glad you brought this up because I think this is a point that needs to be spoken upon. What you're doing there is you're taking a moment and you're judging it today, and you're judging it in a way that isn't natural in how things in that situation occur. And the prosecutor was trying to do that. In fact, when they did the playback of a certain testimony, and they said, you face, Raul Valle is facing that, what he perceives to be a crowd of individuals. Now, when you're looking in the video, it's a horseshoe and there's an exit. And what he says, though, in his mind, there wasn't an exit because it was turn my back and that crowd of individuals comes in on him, which they had already done once, or B, stand there and face them down and try to defend yourself. And he chose, obviously, to defend himself. And then the net result of that was people got stabbed and Jimmy McGrath got stabbed. And if you're talking about the state in their opening statements, that's the moment everybody gets stabbed. So, which the state wanted to have because they wanted to say that the Silva was already out of the pile. Because if he's stabbing while the Silva's in the pile, trying to save the Silva, that's in defense of another, at least for the assault charges. Then they have to, then McGrath, it's got to be considered what the scenario was when he arrives back there. But in the moment, it's about his perceptions in the moment. And in a moment like that, he isn't thinking about fleeing, or he isn't seeing it like we're seeing it. He doesn't know he can flee. Like he said, I can't turn my back on them. All right, here it is. There's a horseshoe. They're around. And what he's seeing in that small snapshot of a moment, it's not what we're seeing when we're playing it back at slow motion or sitting in the comfort of a air-conditioned courtroom or our air-conditioned homes, and we're watching this over and over again, and we're going, yep, right there, he could have left. That's not how it worked for him. He was acting in split-second moments and perceiving things. And again, remember, he'd already been engaged with being beaten down by these people. So when he comes back in, he's just acting. And again, we only perceive in many times. Think of when you think of an experience you've had and you experience it and you watch a video back of that experience. And there are things you will miss. There are things that you won't see. There are moments and things that might have been said that you will not hear or capture because the mind only captures so much because of where our focus is at. And one thing I learned, I remember I learned from a teacher that said, they were talking about parenting pre-Kers, and they said, remember your child can only focus on one thing. And many parents make the mistake of coming down and saying, all right, listen to what I'm saying and look me in the eye. And then the child starts to drift. And they said, well, one thing you're going to learn, you need to learn, is your child can't do both at the same time. They can't listen to you and they can't look at you. If you ask them to look you in the eye, they're going to stop listening to you. They're not going to retain what you have. So you're going to have to let them just check for confirmation that they're understanding what you're saying. And when they said that was like revolutionary to me. But the same thing is in this instance. He is focused on one thing. The mind is focusing on one thing. He's missing everything else. So if people are talking or if he's looking in front of them, he's not looking behind them at the same time. He can't perceive both. He's looking where he's going. He can't hear. And if he's talking, he's not necessarily looking. And when you're in that fight or flight, he's seeing fragments and he's reacting to things, and he's reacting to things subconsciously as well. So I don't think that's a fair thing So when you're looking at this and you're breaking it down and say, oh, he and his friends could have left. Well, maybe at certain points, but again, this is also why the defense missed the moment of explaining the psychology of 16-year-olds where he was boxed in. He didn't really feel like he could leave. He was being baited to come there. So was everybody else. And then as things were accelerating, he became locked into something that became inevitable. And understanding that is also key, I think, to understanding how this thing erupted. ASCT says his friend was out of the fight and on the way back to the car. It's on video. You see De Silva getting beat up while Raul walks back to his car. Well, the thing is again, like I say, like I was just saying, it covers exactly that you see him back at the car, but De Silva doesn't get thrown out of the fight till Raul's coming back in, and all of that is a crossing. And then all of a sudden, Raul is there, and he's surrounded now. And then again, what we do know is that there was again, the tape stops. What we do know from some of the witnesses who would say, yeah, we were beating on Raul. And remember, De Silva hits Raul Valle first because he claims that he was doing it in defense of another, that he thought Raul Valle was going to sucker punch somebody, which again was not something he ever said to the police in his first statement. That was something he came up with. And if you notice, it's a lie. It's a blatant lie. And I'll tell you why it's a blatant lie, because what he was doing was after he became aware of the police reports of how that first fight started, where Raul Valle is alleged to have sucker punched somebody. I believe it was caught on tape even. But where he knew that, he then comes up with the idea of saying, oh, that's how I can explain away my aggressive behavior. Reality was, as De Silva said, when Tyler Rich walks up on them, he tells them, get the hell out of here, I'm going to F you up. And that's exactly what they went and did. And Rich punches Valle, and then De Silva gets hit too, although Rich says he didn't hit De Silva, but somebody hits De Silva. De Silva says he doesn't know exactly who. And next thing you know, he and Rich are on the ground, and then this whole group converges on them, and they start a group beatdown on these two boys. So now De Silva, of course, is the one that's saying that Raul Valle's over there causing problems, and along with everybody else, he kind of joins with the crowd because that's what he's got to say for his immunity agreement. But the reality of the situation is all of this requires us to trust individuals, to trust Tyler Rich's version of events, to trust these other people's version of events, when in this version, we know, based on certain pieces of tape and things that happened, that we know there was violence and we know somebody struck somebody. The problem is it's not in Tyler Rich's best interest to say I struck first and I was the aggressor. Certainly not in Raul Valle's either. It's not in Tyler De Silva's. But they all have an incentive to lie. And the question is, who doesn't? And then when you put it all together, do we have any definitive evidence that shows that exactly what happened, or who's telling the truth or who's not telling the truth? And this is why the American judicial system is one of a kind, because we don't make you prove or disprove a negative. What we say then is that's called reasonable doubt. We have no idea who started it. We have no idea, and there's no way for the state to completely refute, which is what they have to do. Raul Valle has asserted self-defense. This presumption of innocence thing kicks in. He met the preponderance. It kicks in, and now the state has to disprove it. And the state failed to disprove it, and it's that simple. And they don't have any evidence to disprove it. The tapes that they could have had that might have disproved it never showed up because they were deleted on Snapchat. You could see that in the camera. I believe it was Espinoza or someone, I think was the name of the individual who one of the individuals who had a tape of it. But it is absolutely. Oh, you were quoting a troll. Sorry. Well, I appreciate it. You sent me on a nice tangent there. And Dinah El Shama says, I love this channel, same wavelength, not the type of ignorant comments you read on other YouTube chats. Well, I appreciate that. I appreciate the chatters out there, and I appreciate the mods who help us to keep it a good place to come and a good place to debate these things. And Jackie Cellini says, I don't think they're going to retry this case. Well, we will find out. I think it's going to be difficult, which is why I think the judge said, calm down, sir. I don't know when you're planning to refile or file these informations or whatever, but let's receive the verdict first, because this is a much more complicated case for the state now. Lord Paghetti says, remember, beyond a reasonable doubt, 100%, 100%. So this is where we stand now, guys. I'm happy that this happened. At least that this is the result, and that it wasn't a catastrophic guilty verdict on any of the charges, which would have, again, if you would have had any guilties on a first assault in the first degree, he would have been taken out of the court in handcuffs because he would have had a mandatory 5 years, and they would have had every reason to revoke his bond and put him in jail. So for him, he's going home today. But he's not going home free. He'll never be free of this. He's going to be dealing with this for the rest of his life. His life is never going to be the same, and neither is the parents or the family of Jimmy McGrath, and that really is the sad tragedy of this whole thing. So nobody wins today, except that we made sure that the justice system, that the unfairness that was happening within the justice system, the prosecution didn't get their way. And that what I think what we need to take from this is we need to say to ourselves, how can we help police and prosecutors not make messes of these cases and be able to hold the people accountable in a proper way, not overcharge people, charge the right people, charge the right crimes, or find out the right charges that fits the crimes, and make sure that they don't run into this situation where they give away the farm before, they give immunity to everyone, and then what do? What do they get? They get nothing. They get nothing. No accountability whatsoever. So ASCT says, as a Connecticut resident, Attorney Smith has been added to my contacts list. You never know. Absolutely. I would absolutely highly recommend, if you're in trouble, you go to that man. He did a good job. He did a good job, and you could tell he showed a lot of empathy and compassion for his client, and he took good care of him. And I've been on his website checking him out, and it seems that he's got a pretty impressive resume on there. And I like his thought process, and I like the way he argued. I liked exactly what he told that jury, which is, do you trust and believe? Would you trust any of those 25 witnesses you've heard to make on their word and their word alone on a major life decision? And the answer to that is, if you're honestly answering that, no one should trust any of those kids' word on a major life decision. And they shouldn't have done it in this case, and they kind of didn't. Miriam Kamugi says, the law and crime chat for this case was just so ridiculous. Any reasonable look at this evidence was self-defense. I know. Well, it gets a little crazy over there. I was observing some of the chatters over there, and yes, it seems, like I said, there's blinders that go on when someone dies. Diana L. Shama says, I'm relieved he's been acquitted too. He was overcharged, and I hope everyone finds peace in this case. Very well said, and I do agree. I hope they do find peace in this case, but I think that's the saddest part is the McGrath family. It doesn't end for them ever because they lost their son. And then the kids that got stabbed and the kids that lost a friend. I mean, there's a massive amount of loss that goes around, and that this trial didn't solve that on any degree. Even a conviction doesn't solve that. And it's still what it is. And they've all been now, of course, the wounds of all this has just been reopened because the McGrath family just had to re-experience this whole thing in HD on the internet, on YouTube, and everywhere else. ASCT, he is a 5-star lawyer, highly sought after. Yes, he is. And he's had several other cases that he's been involved with that if you go on there, you'll see the impressive resume that he has. It's so true. Unless he moves from Connecticut, he will never truly be free from this, says Miriam Kamugi. Yes, I agree with you. He'll never be free from it at all. I mean, listen, if you search his name and, in today's world, you're a job or whatever, I mean, he's going to come up. I mean, he's been covered now by YouTubers and law and crime and the news. I mean, he's never moving from this. This is a situation where he's locked into this forever. Rosebud says he's not facing anything. He's not guilty. Hopefully that's what happens. Joni Davis says the overcharge was not guilty. The lesser charge was hung jury, but the state called mistrial because they did not want to take any more time on this, so there was no lesser charge for him. I'm not exactly sure what you mean by that. The state actually objected to a mistrial being declared, and they wanted the jury to go back, and they wanted to have a Chip Smith charge done, even though they'd already had the equivalent of a Chip Smith charge light twice, and they'd pretty much covered all the components. I agree with the judge on that, and I think she did the right thing. And then the state stupidly stood up and said, we're ready to file an information. We want the court to know we're going to be filing an information. And it's like, dude, settle down. You need to at least take a second and evaluate how you plan to move forward and whether it's viable to move forward or not. I think that really shows you that this prosecutor was acting out of ego and not anything else. They will be seen as guilty. No one wants to hire liars. Raul will be more successful than all of them. Yeah, well, I mean, I think that's the other thing. Those kids that testified, they're not going to escape this either. Lori Pergetti says, prayers to the family of Jimmy's and friends. So, yes, absolutely agree with that sentiment. Jiffy Negan 22 says, still waiting for someone to explain how is it self-defense when he passed by the friend he was supposedly going back to protect, because there's two elements to self-defense. There's defense of another, and then there's defending yourself. And the way it works here is he headed back to the group, believing his friend was still in the group, and then his friend is thrown at the same time back out, and then he's back in the lion's den. And as per his testimony, which is evidence, he says after that tape stops, he's attacked again. And he's brought, the group comes on top of him and they start to go after him. And it's then that he begins stabbing again or swiping the knife. And it's then he doesn't know when he stabbed Jimmy McGrath, but somewhere in there, Jimmy McGrath gets stabbed. He sees a hole and he shoots out. That's evidence on the record. And as per our system of justice, we are to presume him innocent. You are to presume him innocent. So one of the things right here that I'm going to tell you is we don't have to, or there didn't need to be an explanation of anything of how it was self-defense. The state had to prove why it wasn't self-defense. They needed to put an explanation on why he wasn't defending himself. And that's the problem. The state had a big problem because they didn't have the witnesses to explain that to the jury in a concise way, and they had a problem of theory. Remember, the state's theory is when he comes back and he just starts wildly stabbing everybody at that moment. And then they put witnesses on and say, no, the stabbing happened before that, and then he returns, and then he goes on the record. And their thing was, well, you had the right to leave. You had the right to retreat. But the question is did he perceive that right to retreat? And he testified that he didn't. And it's at that point that the state has to then show that he didn't have the right to retreat, that he didn't know he was going to retreat, or that he knew that. And they couldn't show that. And clearly they couldn't because the jury couldn't agree on it. And there was enough people sitting in that jury room who said, we don't agree and we're not going to come to a guilty verdict on this. But the idea here is that as soon as his friend was out, he's left in the lion's den and he's now defending himself. He just went through a beatdown. He just realizes that these kids are coming after him now and they're beating the hell out of him. And he's acting in defense of himself because, again, remember, the standard of self-defense is to prevent grievous bodily harm, not just death, but where he could be harmed in where he could be harmed in a permanent way, brain damage, broken bones, whatever. And when you have a group of 15 to 20 to 30 teenagers who are now converging upon you, and you've now become their center of attention, 15 or 30 hands and 30 feet can do a lot of damage. And that's if there's 15 of them there or 10 of them there, however many it is. Those boys were doing a lot of damage. And we only look to, again, this evidence wasn't put forth. It should have been. It was only offered through De Silva's testimony. But I do believe they should have talked. They should have tried to get the doctor who treated De Silva the next day in Connecticut, or not Connecticut, in Vermont. And they should have demonstrated to the jury just how much damage he took on. Because according to him, and again, I think it would have been great for the jury to hear this. Yeah, he suffered a concussion, contusions. He was beaten. As per the some of the witnesses' own testimony who were in that car said or I believe it was Jack Schneider, said, yeah, he was like bloodied, unconscious, halfway conscious. He was in a bad state when he got, by the time the adrenaline wore off and the effects of the beating laid in. So that's how we get there. Miriam Kamugi says, I'm from Connecticut, lived 40 plus years in the area this crime happened, live in Atlanta now, but 100% how the prosecutor framed this is one of the reasons why I moved south. Well, I mean, this was not a good day for the prosecutors. And the prosecutors in this case, this is why people should have a distrust of prosecutors who have many prosecutors today have lost track of their purpose. Their purpose is not to win a case. Their purpose is to take a case to a jury where they have proof beyond a reasonable doubt based on the evidence, and that they are to then show that jury the map to that. They're not there to win. They're not there to twist things. They're not there to do immunity agreements. They're not there to create evidence. They're there to deal with the evidence. And when there isn't evidence or a case doesn't fit the charges that were originally there, they have an obligation, as much as they have an obligation to seek a conviction, they have an obligation to also dismiss a case, amend charges, downgrade charges, or dismiss charges and send it back to the police and say, we need additional investigation and we can come back later on once you answer these things. That's what prosecutors should be doing. They should not be sitting there relying on jailhouse informants to make cases stronger, where they know these jailhouse informants aren't credible, doing immunity agreements with witnesses and essentially pressuring them to manufacture testimony like you saw in this case. Those are things that should not be happening. That is not what prosecutors' mission is. Prosecutors should be following the evidence, and they should have the courage, and they should have the fortitude, and they should have the ethics to dismiss a case when it needs to be dismissed, downgrade a case when it needs to be dismissed, and understand that that is as much of a victory as a conviction is, because that is what the evidence called for. They're not here to win, and neither is a defense attorney. Just like a defense attorney has an obligation to decide and help his client see the best path forward. In some cases, they go in, they ask questions, they raise questions, and a conviction occurs. They didn't lose. Not if they gave this person the best possible defense, asserted every defense they could, asserted every right on behalf of that individual, and the jury comes back and convicts them. Hey, you know what? That's how it should work. And no defense attorney should be upset about it. They should only be upset if they didn't do something, or they didn't prepare for a case, or something got missed. Aussie Mamal says he could have left at any time, but chose to get back to the party, provoking the situation, ended up stabbing 4 kids, killing 1. He now walks free. No justice for the grieving family. Okay, well, there's so much wrong in that statement. It's crazy. First of all, he was brought to the party by Jack Schneider. That's number one. Number two, Jack Schneider was driving the car and drove him back. He didn't have a ride readily available there. As we saw on the tape, these kids were advancing up the street at him and keeping this fight going. And see, this is where the honesty of the moment and then the pressure from prosecutors to make a case converge on themselves. If we're honestly speaking about what was going on, these kids at the party, as you could see in the ring footage, they're storming up the road. They're keeping this thing going. Tyler Rich was not trying to defuse anything. He had his shirt off, okay? If you know anything about people who take their shirt off in the middle of a fight, that means they're ready to fight. My 15-year-old, 16-year-old explained that to me as we were watching that video. And he said, oh, yeah, look, a couple guys have their shirts off. That means they're ready to fight. That is exactly what that meant. These guys were ready for a fight. And I thought that was something that maybe I need to go back and watch, but I think the defense attorney should have made a bigger deal of. It was like, okay, these alleged guys who just wanted people to leave, why your shirt off? Why's your shirt off? I went back in the house. Oh, yeah, but your shirt's off. So you had time to take your shirt off and then engage in a fight. I mean, come on. That's ridiculous. So, and there were several guys with their shirts off. So these were guys who were not trying to defuse anything. They were ready for a fight. They were ready to throw some hands. They were ready to assert their manhood and show how tough and powerful they were over others. Lori Paghetti says, WD-40 in the eyes. He could have died by one swift kick in the head. This was a very dangerous situation. That is absolutely correct. And let me tell you, I know my dad had a case, and I remember listening to the interrogation tape of the guy in this case, and my dad ended up getting the individual. He ended up getting him off because it was self-defense. But basically, what occurred, he was charged with manslaughter because there was a bar fight, and they came together, and bam, one shot. Guy fell back, hit his head on the bar stool. They charged him with manslaughter. Now, this gentleman, of course, they had a trial, and perhaps you'll see it. I have the articles on it and everything. So maybe when I decide to do the rundown of my dad's career, you guys will be able to see some of the articles from this case. But I remember listening to the statement, the police statement, because my dad would oftentimes be driving around listening to police statements and things in his car, because he would get CDs and things and have them on and put them into his car, or he had a cassette deck. But the point is, one punch, that's it. That's all it took. And in that case, it was one punch. The guy, the guy came at him. That guy swung on him. But this guy got in, ducked or something, and wham, one punch. Hit him on the face, fell, and hit the back of his skull. Pop. Karen Reed talks about that, where, it was clear that when he fell in that case and hits his head, whether it's in the basement or in the street or wherever it was, he was able to fall, and that impact on his head killed him. So in this case, the idea here, and this is what kids don't think about when they're doing this. This is what I've explained to my sons. You guys get all pissed off and you think, oh yeah, I'm going to go punch this guy out. I'm going to go do this. You don't understand that one punch could change your whole life. You hit somebody in the face, and maybe you were doing it in self-defense, but society, police, prosecutors are not going to let you walk away without a trial. A case is going to get tried. And then you're going to be in the position of Raul Valle, where this young man hasn't been free. He's been on home confinement, house arrest. He's had this weighing over his head. So Miriam Kamugi says, it's a hard fact that the family of Jimmy McGrath needs to accept is that their son chose to be part of a mob who started the attack. I feel terrible that youthful aggression caused the death, but the jury got it right. Absolutely. And that's something I think the guy lost in it too, is this idea that Jimmy McGrath is just completely innocent bystander. He was involved. He did not deserve to die. Should never have ever happened. And it's sad that this progressed to this point, but it's also I think it's a lesson for young kids to know, hey, listen, you really can't be anywhere around this type of stuff. Bad Barney, No Bullet says, you are not trespassing when you are texted the address. That's exactly right. That's what I've been saying. Aussie Momal says, no self-defense when you claim you were in danger, but yet come back with a knife. Should have stayed clear to begin with. Okay. Aussie Momal, again, you've got to look at the facts of this case, because what you're saying is just not at all aligning with the reality of this case. This was not a scenario where, first of all, he was brought there by a third party where he had no choice over the matter of whether he went or not. Even if he wanted to go there, he wasn't driving the car. Jack Schneider was driving the car. Okay? Now, once his buddy's car gets attacked, he and De Silva decide to go down there. They're not going down there to attack anybody. They're going down there because they think they're going to talk to some people and try to get this situation worked out. And then what happens? He's sprayed with WD-40, and he doesn't attack anyone at that point, which I thought was interesting by Tyler Rich's testimony. They're like, oh yeah, he's going to sucker punch him. That solely came out of that first fight where it's alleged, well, I think it's proven that he started that fight with a sucker punch. But he hadn't done anything like that. I think he was a little out of his element. When you look at his size compared to all those other guys, does it even make sense that this kid's going to think, yeah, I'm going to go kick the ass of these 30 big dudes, football players? Come on. No. They're coming down there. He thought he had his friend. I think it was Aiden Hart or something. He comes down there, and I'm looking for Aiden. De Silva's looking for Rich. Rich comes down and basically turns into an asshole and says, hey, you get the F off my property, I'm going to fuck you up. And guess what? That's exactly what Tyler Rich began doing. He punches Raul Valle in the face. He goes after De Silva. De Silva takes him to the ground. Raul Valle, next thing you know, the crowd is, bam, their leader's been activated, and they come on in. Shirts are off. They are ready. So my question to you, Aussie Mama, Go watch back that video. Are you not I mean, do you not have a problem with the guys with their shirts off? You think everybody's running around that party with their shirts off? No. No, they're not. Okay. They were ready for a fight. They'd taken their shirts off. They were ready for combat. They were ready to go in there and start kicking some people's asses. And that is exactly what they did. And they started to beat these two boys. And had a knife not come out, again, I very firmly believe we would have had a very different trial. We would have had a very different news headlines. And we'd have been learning about the Connecticut football players and lacrosse players that beat one kid to death and put another in the hospital. And it would have been, and everybody would have had a totally different perspective on this whole case. And Raul Valle's family would have been the ones in that courtroom, and De Silva's family would have been the ones that were victims. And who knows? Maybe Jimmy McGrath would have been one of the ones charged because he was there and seen on tape. And we would have had a totally different situation. The bottom line is that if we would have had a prosecutor who was actually looking at this case with an intent to charge this thing properly and to charge what actually happened, we wouldn't have gotten what he was charged with. And we certainly wouldn't have had a necessity of immunity agreements. And if they would have treated this like it should have been, which was a case at best recklessness. At best recklessness. Give me one moment. Sorry about that. I had to make an adjustment on something. So but I guess that's where this should have always been at. And then there would have been a much better opportunity to negotiate a plea. There would have been a much better opportunity to have held people accountable. And maybe you could have used a reckless aspect too of across the board of trying to get other people charged in this case and held accountable for their behavior. So we would have to see, Joni Davis says, we would have to see the text. Raul was looking for a fight, wanted the address, and got it. Went there uninvited, started the fight, proceeded to kill someone. Joni Davis. He didn't drive there. His friend drove him there. So we can start there and debunk the idea that Raul Valle gets credit for going there. He was driven there with his girlfriend on his lap. They pull up, and Schneider starts chirping, and they start talking, and that is verified by, if you believe any of the witnesses, that's verified by the witness statements, that when they pull up, they start chirping. They start talking to each other. And then, again, who starts the fight? How do you believe he starts a fight? Was he out there attacking Jack Schneider's car? Was he breaking a windshield? Was he ripping a bumper off a car? Was he shaking a car? Was he a part of the group of 40 kids? So you left that part out. So you got to be at least a little fair in how you're looking at this, because what you said there is not at all backed up by the timeline of events or the evidence. Now, he may very well have been, chirping back and forth. That's possible. AS Connecticut says, Allsy, you are factually wrong again. The first fight at the residence was between Jack Schneider and Ryan Hines over the beer. Raul did not start the fight. Try that again. Joni Davis says, how many witnesses said he wanted to fight? I know someone. Well, again, what's the credibility of the witnesses that said he wanted to fight? Are you saying, Joni Davis, which you apparently don't even know which witness you're relying on, but are you telling me that the witness that said that you would rely on that witness to make, let's just say you had to make a decision for someone very close to you, take it as a significant other, a child, a parent, a friend that's very important to you. And that person came out and said, you've got to make a decision right now what to do. And I'm going to give you your options. And this is it. So, and this is what I am recommending you do. And you've got it, but you're the one that makes the decision. And this is what I recommend we do. Would you follow that person's guidance? Would you trust in their guidance? Would you trust in them and say, yeah, I would rely on them? Absolutely. Let's go ahead and do what you're saying. I don't think you would. And if you wouldn't, then you don't have proof beyond a reasonable doubt that Raul Valle wanted to fight. If you would not trust that witness, that is the standard that you have to put forth in this case when you're evaluating things and you're looking at it. And in this case, there wasn't a witness that came from that fight who you could rely upon to tell you anything of importance. They were all either self-serving or drunk, or maybe didn't see anything at all and heard things, just like you said, just like the greatest example that the defense attorney brought forward was Tyler Rich. When he said he saw like a machete or it was like a switchblade or something that he was running around with. And then he had to retract that because he said, well, I heard from someone else. So I was telling what something. No, what happened was he heard from someone else. He went ahead and made himself a witness. He tells the police that in a sworn statement to the police and then had to go back and retract that. And that's exactly what happens in these situations. And that is exactly why these kids couldn't be trusted. These witnesses couldn't be trusted. And there's no way you could rely upon this group of kids who were drunk, who were stupid, who have their own incentives, who have their own motives. You can't trust and rely upon their word. And I don't believe anybody that says that they would is telling the truth if they say they would. And Miriam Community says, and not to be catty, but Jimmy McGrath's family had the nerve to go do a GoFundMe for his funeral when they live in a multi-million-dollar home. Well, I think that was maybe more to raise attention to things, probably. Dalton says no one saw anything. And Mark Chapalonis, someone new we haven't heard from. OJ, Casey Anthony, Karen Reed, Raul Valle, all free. Ridiculous. Well, I don't think necessarily Raul Valle deserves to be in the ridiculous category. I think this was a good one. So to me, I think Karen Reed, the same situation. There was no way that a jury could sit down beyond a reasonable doubt and trust the case and the evidence that was put forth and say exactly what happened. There just wasn't. There was no way they could. Jury got it right in Karen Reed. And Casey Anthony, I predicted that not guilty long ago. And O.J. Simpson, same deal. If you understand the inner workings of the O.J. Simpson case, that had nothing to do with race. It had everything to do with the issues of that were going on at the L.A. crime lab, the LAPD crime lab, and the criminalist, and the idea that all of the blood evidence, the mountain of blood evidence, had to pass through those things before they ever got out to the testing places. And the fact that one of the things that the jury relied upon, and one of the reasons why they had such doubt about that case, was because when it was disclosed that all of those blood samples, the majority of the blood samples that came from Bundy were stored in a vehicle in the hot California sun, and the refrigeration in that vehicle was broken. And here's where the problem comes in. And they were alerted to this the defense was alerted to this, which is why they ended up asking for testing to be done in the blood samples. Some of those blood samples came back pristine with no degradation, no issues. And this is the part that could never be explained. And these were the alleged blood samples taken from the drops that were later confirmed to be OJ's. They found EDTA in them, in one of the blood drops at the scene, and then they found it also in the black gate. But the big factor that they found was these were pristine in condition, meaning they had a high concentration of blood in them. There's no way they could have if they were stored in the hot heat of California all afternoon. They would, and this is where it comes in. This is why a lot of people go, why would they plant evidence? They didn't plant evidence in the OJ case because they were trying to frame him. They planted evidence because they thought he was guilty, and they destroyed the physical evidence. And then they got caught. And that's the real truth of the O.J. Simpson case. That's why the blood vial went missing, because they realized that the incompetence of the criminalist in that case destroyed the evidence that they thought that they had, and they assumed that it was going to prove O.J. Simpson guilty, so they went ahead and they manufactured the evidence in the bindles. It wasn't done, and that's why they said, oh, well, why would they do all that stuff? Why would they take the risk? They took the risk because it was either that or they were going to have to admit that they just bungled the biggest case that they were ever going to handle with all eyes of the world on them. So they went in and they figured that he was guilty. And what they didn't anticipate was that there was going to be problems. There was going to be timeline problems. Then there was going to be the issue with the glove, where the prosecutor asks him to put the glove on and it doesn't fit in front of the jury. And then you've got the problems, of course, with the glove that's found at the house, which they were later tipped off to, which says that, okay, how did that glove make it over to the house? Well, it either made its way over with OJ, but here's the problem. That contradicted all evidence. Why was there blood coming up the driveway? Why was there no blood in the walkway? And they had all these problems they didn't anticipate. And they didn't think, oh, he's going to have a team of high-powered, fancy attorneys that are going to come in and bring up all of this to a jury. So when that jury was left with a decision, they returned the only decision they should have returned, because they couldn't trust any of the evidence and they couldn't trust the police. And the one guy who finds the glove states in the one piece of the Furman tapes that got put before the jury had nothing to do with race. It had everything to do with the fact that he said he would pull people over. If a black man and a white woman were in a car, he had no problem tearing up their driver's license and manufacturing evidence. And once that went before the jury, and you had all the problems with the evidence, you had the EDTA that was found, you had mishandling of, you had the idea that the criminalists said that they didn't follow protocols, that they essentially destroyed the blood evidence, but the destruction of the blood evidence never showed up in the, so even the DNA tests themselves ended up contrary. But nobody ever got that. Nobody ever got that information. All we ever heard from the press, anybody that didn't go deep into it, all you got was race. And that's not the whole story of O.J. Simpson case. And I happen to have, I know some of these things because of inside information. But anyways, I'm not going to get into that on this. But you guys didn't get the full thing. And that's the way it is. So you put up all those three things. The Casey Anthony case was a well-fought case by, where doubt was raised. I remember predicting, I don't remember all the specifics of Casey Anthony. I remember reading the book of Jose Baez after the case. But off the top of my head, I don't remember that case as well as I do the OJ case. But bottom line is that this is what's supposed to happen when cases are not either, because in this case we had a prosecution who puts up a bunch of unreliable kids and offers immunity to some of the key actors and ensures that nobody can know nobody knows what actually happened, because everybody's got their own motives to tell lies. All right, let's see here. Bad Barney No Bullet says, yes, Dalton, I had to be home at 8 on a weekday and 12 on weekends. I remember I had to be home when the street lights came on in our neighborhood, and we would have to, as soon as those street lights came on, we had to be back up at the house. If we weren't, man, my mom was standing out front calling and yelling, and you knew if you come in the house, you were in trouble. But curfews are things of the past, I guess. And that's true too, because I'll tell you what, a lot of my son's friends, a lot of them are out. There's a lot of parties that go on, and I think it's a different time we live in right now, that some of those things could absolutely have served to protect Jimmy McGrath in this instance, or just having an adult there, like a responsible adult there. All right, so we have a question here. If in the texting exchange you could determine Raul wanted to fight and ask for the address, would you still claim self-defense? Well, yes and no. I would, if you're saying if that Raul was the one who said, I want to fight. Now, if he was being invited to come over for a fight, this is where you have to look at the teenage psychology that says these kids, the way that lands with him is an attack on himself. It's an attack on his manhood, on his social standing. So the way he sees that is he's got to show up. He's got no choice but to show up. But self-defense, just because he agreed to a fight, okay, and this is a real distinction here. Just because he agreed to a fight doesn't mean at that time he was planning to bring a knife with him. And the evidence shows that he was not planning to bring a knife with him at that point. That none of them were thinking, we're going to go knife somebody down tonight. They were thinking they were showing up for a fight. They didn't realize 30 to 40 kids were planning to come and destroy the vehicle. We're going to come try to drag them out of the vehicle and beat the hell out of them. So what you're saying there, no, I think that it's a fight does not mean that suddenly he can't claim self-defense when 30 people come out. If you come and agree to a one-on-one fight and then out of nowhere, 29 other people come running out and start beating on you, and you've got a pocket knife in your pocket that you keep there all the time, or you've got your keys or whatever, and you pull it out and you start using that to get out, as the defensor said, that's like a shovel when you're down in the grave and someone starts throwing dirt, you're using a shovel to get back out. That's a tool. That's something you're using to escape a situation that you didn't realize was going to occur. You thought you were coming for a one-on-one fight. We're not talking about an errant punch. We're not talking about where he comes in and he punches, or we're not talking about where he challenges someone to a fight, gets out of the car, knife out, and goes over and knifes the guy to death. That's not what we're talking about here. So, no, Joni Davis, I don't think what you're relying, I don't think that makes a difference at all. Because if he was agreeing to a fight and he shows up for a fight and it turns into a mob group beatdown, he can still claim self-defense. I think you're biased if you're still defending. So by your definition, the kids that invited him to the fight, why would you not say that they should be charged then under your theory? That the other kids that were participating in this should not be charged. He wasn't ever saying he wanted to fight Jimmy McGrath specifically. They were telling him, pull up, show up, you guys are pussies, basically. That's what they were telling him. That's what the messages were. You guys don't have the courage to show up. And they showed up to say, yeah, we do. We have the courage to pull up. What are y'all going to do now? Well, unfortunately, they came out and destroyed the vehicle. Then it became a catastrophe. Miriam Kamugi says, these teenagers speak text differently. Pull up to them means aggression. They don't use it how someone 25 years older. No, they do not. And that's exactly correct. Or slide or all the different. I mean, let me tell you, I have a 16-year-old and a 19-year-old, and they talk things that you don't even realize you would even think mean something or means something totally different now. It's ridiculous. They have a whole new language. It's like a whole nother language, a whole nother world when they're talking. And a lot of it also, too, they have abbreviations in their text messages and ways they talk. It's completely crazy. Buddy Light says, I didn't catch it all. Did they have a car and could have left? Sort of, kind of, not really. At different parts. There was a car that they had. They arrive, group comes on, and they basically, 40 kids come out and rip the bumper off the car, break the windshield, and they end up having to try to basically speed up and out of the group. They pull off. They get out of the car. They're trying to assess the damage to the car. They then make a decision to drive back around the block a few times, and allegedly, according to the witnesses, if you can believe them, they're throwing things out of the car, and they're pissed off that they've damaged their car. They end up down the road, and then essentially they make a decision that De Silva and says, take me back around. I'm going to go talk to Tyler Rich. This isn't right. We need to talk to somebody about the damage done to the car. Like, this is crazy. And Raul Valle agrees to also accompany De Silva back to the party to talk to them. So they are brought back around, and then the car pulls off again. And they then walk down to try to find Tyler Rich. Raul Valle's trying to find his friend Aiden to try to talk to them. And in the process, Raul Valle gets sprayed down with WD-40. And then eventually he's talking to someone. And now Tyler Rich says Raul Valle was going to sucker punch his friend. But eventually Tyler Rich comes to meet with De Silva and tells him, get the hell off my property or I'm going to F you up. And then turns around and punches Raul Valle in the face. At that point, Raul Valle begins being beaten down by a group of kids who then engage with him. At that point, De Silva at some point gets punched, and then he reaches out, and he and Rich get into it, and then you see the video. and where they're struggling on the ground and the kids are beating him. And Raul Valle then says, on his way out of the car, Jack Schneider had flipped him a knife and said, just in case you need this. Raul Valle picked it up and put it in his pocket. He says after he's getting beaten and is getting converged on by about 10 to 15 kids, he pulls that 3-inch pocket knife out and starts waving it around, trying to get them off of him, not intending to kill anyone, but just to get them away, never dreaming it would kill anyone or do major damage. He ends up getting away. The car returns, or in the meantime, the car had returned. He runs over to the car, goes to get in the car and realizes that Tyler Da Silva has not made his way back out and heads back over. As he's heading back over, Da Silva's thrown out, and the kids converge on Valle again, and start beating him again. And he's again uses the knife to kind of try to get the kids off of him. He dives through a hole, and in the process of that, Jimmy McGrath got stabbed. To which he jumps in the car, disposes of the knife, comes back, gets in the car with his girlfriend, and goes home. And then the other kid, and Tyler Da Silva, then is semi-unconscious, bleeding in the car, and he's taken home. And then here we are. So this is a case where, yes, the car was present. He was brought to this altercation by a third party. He did not drive there himself. Parents need to be accountable. You be on that stand looking like a fool. I think what you're saying is the parents need to be accountable with these kids, and they're on, look, these kids are up there. If the parents were accountable, the kids wouldn't be up there looking foolish talking about this stuff. Lito was the passenger, right? Yup, I have a 17-year-old. First of all, they're in group chats and can be hundreds of people to dozens of people. Absolutely, yep. It's very dangerous, with the way, and dangerous from the standpoint of it allows things to accelerate much faster, and the reach of these things. School never ends anymore, so you need to be aware of that. If you're a parent out there, school never ends. They never leave. If your kid's getting bullied, he's getting bullied in your house on the phone if they have a phone. Whatever is happening at school goes right home. There's never a stop. That's why you see some of these kids commit. Well, I can't say that on YouTube. But that's why some of these kids end up taking some really drastic steps, and it's because it never ends. The pressure cooker never ends, and they feel like they're never going to escape anything. Joni Davis says, I never said anything about the other kids wanting to fight. It was only him wanting this fight, and shows up at a place uninvited. And okay, but Joni, the other kids did want to fight. He did not show up at this party alone going like, I'm looking for a fight, guys. No, he showed up there with a group of friends. That's not how this went down. So Bad Barney says, Bad Barney No Bullet says, it is a far cry from evidence. Roger says, Raul got sucker punched. Yes, he did. And he did. And that has been testified to, but he claimed he sucker punched him because he thought Raul was going to sucker punch his friend, which is convenient because he was basically mirroring exactly what Raul did at the other party, the Lifer Lane or whatever that was. If my kid, don't you be on that stand embarrassing me either. We got a problem if so. Well, Dalton, I know. The parents, I'm sure, feel very embarrassed by what they saw up there. If their kids were something against. Roger says, no knife found in woods. That's correct. They never found the knife. Buddy Light says, thank you, at Justice for Process, for explaining that. No problem. Absolutely. And Bad Barney says, no knife found anywhere. That is correct. And why kids have flip phones until they can buy their own? Well, I think, in a way, this case makes a case for why maybe, there should be limits. John L., did you watch the trial? I don't know. Did John L. say something? Must have been someone back deeper in there. The knife was never found. Oh, okay. He was the individual asked about the knife. And Joni Davis says, if. Well, if. Well, the thing about it is that's not what happened in this case. And we have to deal with what happened in this case. And what you're saying, and the way you're isolating him, acting like he was an isolated lone wolf,
guy who just comes in, look bloodthirsty, looking to come in and kill people, is not how this went down. It's not a fair assessment. And it's not even something that can be considered, because it's just not true. Straight up not true. Anyways, well, guys, I really appreciate everybody who watched the trial. I appreciate everybody who watched with us. I've got to get ready to go. We've got to head to the great state, into the mountains of the great state of Pennsylvania. So we're going to be traveling here. And then we're going next week down to South Carolina. So we'll be traveling down there. So we got lots of travels to do. And we've got, of course, two other trials going on. We've got the bench trial out in Iowa of the college student who attempted to strangle a young lady to death and stole her $20,000 earrings. And then we've also got the wife who is alleged to have killed her husband with the intent to collect life insurance and run off and have a happily ever after with her lover, her like 20-year younger lover. And that case is going on as well. So I'm sure we will meet in there and talk about that case. Not nearly, to me, as interesting as this case, because that case seems to be a little more cut and dry. But, they do seem to be having some, I think, decent defense lawyering going on there. So I'll be curious to see how the defense handles this case. I can't imagine them just resting, but maybe they are. I think they're going to have to put the wife on the stand, but we'll see. Maybe they won't. Maybe they'll rest and just rely on reasonable doubt. If they do that, I don't think it's going to go well for her, but we'll see. All right, we're going through a couple of comments here. Only one cell video to fight. Seems like, there was definitely more floating out there, Roger. You're touching on something very important. Mellis Montana Yoga, thank you very much for tuning in, and thank you for being here. And I'm happy to provide this space for everybody who wants reasonable. And again, you don't have to come in here and agree, but what we want is a space to agree to disagree in a nice way. Raul had no violent background, and he doesn't look for trouble. That's correct. That is correct. There was not one shred of evidence put on that he was. It was premeditated, says Aaron. Aaron, do you have evidence that we don't know about? Can you please, or point to me the evidence in the trial? I'll be waiting. Janie Marshall says, wow, wow. And Bodie says, see you good people next time. And Joni Davis says, I wish we had some of those texts. They would tell a lot. Well, they do have texts. I do believe they have some of them. But the reality is I think what they would tell is the story we already know. That this was a group effort among kids that accelerated, and that this was something that was a result of this group acceleration of emotions among these young teenagers. And it was allowed to accelerate because of access to social media, which is something, I'm not blaming social media. So somebody got excited yesterday and said, you're blaming social media. I'm not blaming social media. I'm just saying it offers the access point. And if it's not managed correctly, this is what happens. Bad Barney says, great commentary. Thanks for the channel and great chat. Keep up the good work. Well, thank you, Bad Barney. No bullet. I appreciate it. And thank you for modding. And thank you to all the mods out there that are in my chat each and every day and that show up. Very much appreciate you. And Nina Ninaro says, Raul, go on with your life and do something good and productive for a young man like you. Well, we hope that that's what he will get the opportunity to do. He's still got a little bit to work out here. And maybe the state will decide not to charge him and let him get on with his life and try to put the pieces back together. We'll see. I don't know. I think that's what should happen here, but we'll find out. So with that said, guys, I'm going to sign off here. Look forward to talking with you guys again. Look forward to seeing you in other chats and other cases. And if we have another Raul Valle trial, we will be covering it. And hopefully I'll see all of you there as well. So until then, guys, let justice prevail. Remember, justice always works better when we watch, so keep watching, whether it's here, whether it's somewhere else. Keep watching. Keep your eye on it. Let them know that we're watching. And as my dad always said, it works much better when we do that. So keep doing it. Anyways, guys, until then, let justice prevail, and I will talk to you guys soon.
System's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. Rise up now, it's our time to shine. United and free. We'll write a new paradigm, new paradigm. United and free. United and free. United and free.